As the GOP presidential candidates face off in South Carolina, another political struggle is brewing in the halls of the state's Supreme Court. Greenville, Beaufort, Spartanburg, and Chester counties challenging the state's authority to put on South Carolina's First in the South primary. The counties say they would be stuck with $1 million in bills from the cost of putting on this primary.
This matter could have been resolved if they had stepped forward, but they didn't. So our county taxpayers believe that they should not be saddled with the burden of conducting this presidential preference primary.
The fact that only 4 brought a lawsuit, and the justices brought up the point, these are widely different costs that some of these counties are trying to get approved. And so I think it goes back to that, and I think that I'm going to trust the Election Commission to approve the costs that are legitimate.
State GOP Chairman Chad Connolly argues this year's budget law contains language that gives the State Election Commission the power to run this primary. However, in court, Justice Donald Beatty said lawmakers had a difficult time passing any law about paying for the 2012 primaries, and Collins, who is representing the counties, says only the legislature can grant such power.
State agencies have only that authority which they are given by statute. That's the fundamental rule of democratic government.
I don't think there's any case that counties can decide which laws the state passes that they can follow. I think that's what the argument is. The State Election Commission runs this. The county election commissions exist to run elections.
In court Monday, Chief Justice Jean Toll said if county election commissions were not required to run primaries, it would be more difficult for people to vote.